now, you have to hire a $1 million expert witness, or if there's other costs. You can withdraw most of the time, but even though you're otherwise permitted under those other provisions, you must comply with any law requiring notice or permission by the court. Somewhere, I'm sure in the Iowa Rules of Criminal Procedure says a lawyer withdrawing from a criminal case must seek the court's permission, and you have to comply with that. And I can pretty much guarantee what the answer to that request will be. The request will be no, you cannot withdraw from the case. So as a practical matter, a criminal case, or possibly even a civil case, because the civil case, there's probably something in the rules of civil procedure saying that you have to give notice, especially if you're very close to trial or something. So you still have to comply with that. And if the judge says, no, you're going to be working on this case, well, then all these other factors don't matter. The mere, you have to watch out when the judge uses the word mere, because they'll go, okay, well, the mere fact that you've been unpaid, you know how that sentence is going to end. So the moral of the story is to get paid up front in criminal cases. So the court says so, you have to keep going. But even if you quit, you have reasonable steps to protect your client's interest in any situation. You can't quit midstream. In fact, even under the rule about us getting paid, even there you have to give sufficient notice. So if you just want out of this case and you send a bill on the first, on the second you say, I quit because you didn't pay me. Well, no, you have to maybe give them a little bit more notice than that. You have to, if you get with your client, you have to give your client's papers back to them. Now, period. Now, the rule says here, you have to give the papers back if the client is entitled to them. Don't read too much into that, because the client is entitled to them. Even if you haven't paid, the client is entitled to their papers. Papers belong to the client. The reason those words are in there are for a work product that you are creating and getting paid for. So your client wanted to draft this complex trust agreement that spent hundreds of hours of your time going into putting this thing together. And then he comes in and says, oh, you're fired. And by the way, give me my file back. Well, one of the papers in that file is that thing that you spent tens of some dollars of your time looking at. Well, you don't have to give that, because that's what he has paid for. But you have to give him back the rest of the file. So that if the client is entitled to only by those work product type of things. Now, you could have, for example, an agreement with your client. Maybe your contract says, well, you're probably entitled to make a copy of the file, and maybe your retainer agreement even says the client will pay for the cost of the copy. You can pay that agreement, that's fine. But you probably can't condition the return of the file on payment of those copies, because the file works for them. Now you can make a copy and send them a bill after the fact, but you can't keep the file hostage. Give it back to them. And it's not going to do you any good. You just make people mad. I shouldn't think of that. Yeah.
But what about court files? Can I tell them that they're going to have to go to the court office and get they have access to the file? So do I have to give them anything that was or anything like that?
Yeah, those papers belong to the client. You mean you're saying there's another copy down at the courthouse?
Yeah. They have a file down at the courthouse and they can come on and get a copy. Why should I have to give them a copy? I mean, I can understand other stuff that they gave us, but if it's a court file that was filed to the court, I have to give them a copy of that.
Oh, you don't. I don't think you have to put things that don't already exist in printed form.
Yeah. Anybody else have that? What do you guys do?
I'm curious. Yeah, if you've already made copies of everything that you received, sent them to them, and they say, well, I don't have it anymore, then...
So you still don't have to give them a copy?
I don't know.
I would give it to them.
Well, but unless it's
solid.
Well, Right, but I mean, and I understand giving them a copy of that, but I mean, at that point.
No, you give them whatever's in there. You can make a copy yourself if you want. I mean, in the situation, if I would not tell them, oh, there's a copy of this, just go print it yourself off the internet. I wouldn't say that. I would give it to them. Now, if, oh yeah. But you don't want to give nasty clients any more ammunition. Yeah. I mean, are you talking thousands and thousands of pages or anything?
Well, maybe, like 400 pages, and
yeah.
I don't want to take the time. I don't want to pay my secretary to time to take copies when I already found a copy. That's crazy. You know? It just makes me mad that I have to take my time out, take copies when they have a file down in the courthouse, and I've already sent them copies. Yeah. And then they owe me money on top of that. I don't think it's fair. I don't think it's fair.
Yeah. The practice of law isn't fair.
Yeah.
No. Well, yeah. Yeah, I mean, if they're demanding the file, if they were, I want file back right now, I would just give them a big file folder, and then if you, also, what do you need it for? I mean, if they make something, if you really need the document, well, you get them out of the court later, such time as you do. You know, so if you really do exist, and you're sure you're going to be able to access them, a year from now when it comes up, I would say don't worry about it. Just get the copies then when you need them. And the smoking gun showing that it's all your client's fault. Make sure you make an extra copy of that one, I guess. Part of the reason why I'm doing CLEs is, I enjoy the practice of law, but sometimes those clients make it would be great if it worked for the client.
We do if the client usually retainer draft, let's say the lease or something of that nature, but it doesn't cover the entire lease. I'll say the rest will be it. What part of the lease do you do?
I don't know. Your client isn't going to it.
Exactly.
Yeah. I mean, I'm just kind of a gray area.
Well, the attorney's law reads that the attorney has a lien for general balance compensation on any papers belonging to a client should come into the attorney's hands in the course of federal law. So do we disregard the stuff anyway?
That's interesting, because I don't think the Minnesota attorney lien statute says that. That's interesting, because, I think that's part of the Minnesota statute. And this is just a model code that they adopted, so maybe,
This 602.1016.
Oh, okay. Well, then, maybe in Iowa, the client is not entitled to papers. Yeah, I'm aware that you have an attorney's lien statute in Minnesota, but I don't think it covers that. I think it only covers the things it's kind of like mechanics leakage, I think. Where you have to actually, create the value. You do a cause of action or in the doc or whatever.
There are clauses you can't keep anything that's going to materially damage your client or could.
There are certain situations where you are allowed to damage your client. Like, for example, if they accuse you of malpractice, you're allowed to say what really happened. So it's not always easy. Well, maybe that if the client is entitled to them, maybe it is a little bit broader in Iowa than it is in other states because of that statute. So that's what was the site for that again?
It's the Iowa Code Section 602.10116.
10116.
10116.
Okay.
After the 602.
Okay. That's interesting. I'll take a look at it. We have that material, and I'll take a closer look at the Minnesota one too. So, returning papers to well, in the Minnesota statute or the Minnesota rule does go a little bit more detail too. We don't have it. I guess that's in connection with that statute. We talked about this a little bit before. You can't have anything of value to recommend your services. But that's kind of what's going on if you sell your law practice as a going practice. So if you do that, that is permissible, but you have to make sure that you comply with these rules. And basically, if it's a bona fide sale of the practice, it's okay. But if you're kind of if you're using this as a ruse to have a referral fee, then it's not okay. So for it to qualify, you have to cease practicing law either entirely or in a particular geographic area or some area of law. So you're retiring from the practice of law and you're selling practice to somebody else, or you're selling your domain office and keeping your suit office. That's okay. Or you're selling your DUI practice, but you're keeping your bankruptcy practice. Okay. But what they're getting at is you can't. I'm retiring from the Smith case, and I'm going to retire Goat case or whatever. You have to really sell practice. You have to give notice to clients still when you retire, and the fees can't go up. So the new guy has to charge your old fees. Okay. Well, Rule of 1.18, I guess we already talked about this one earlier. That's the duties of the prospective client. When somebody walks into your office and says, "I'm thinking of hiring attorneys," basically confidential information, you might be precluded from taking things. So have somebody out in your front office running interference. Well, after about most of the day, we finally finished Rule 1. But don't worry, Rule 2 and 3 and so forth goes much faster. Rule 2 talks about the various functions that an attorney advise our clients. This rule just says that when you're giving advice to clients, if you want to, you're under no obligation, but you can give advice to them, your personal advice, moral, economic, social advice. So, you're representing the bank and they're going to foreclose on somebody's mortgage on Christmas Day. If you want, you're under no obligation. If you want to say, well, that might look bad in the papers, so you can give them that advice. Rule 22. Well, no, it's not so easy anymore. I used to say that that's the easy one. But in Minnesota and Iowa, there is no Rule 22. Well, in Nebraska, that rule doesn't exist. I don't know what 2.2 is. But the reason why is after that, the numbering scheme gets off, though, because Minnesota, Wisconsin just skipped that number. Nebraska wanted to keep things sequential. So the next rule talks about evaluation by use of third persons. That's Nebraska Rule 2.2, Iowa Rule 2.3. And yes, you can, if your client, you're representing in the personal injury case, and his rent is way overdue, and he wants to call the landlord and say, "Don't worry, we're just about to settle this case. He's going to have $1 million any day now, and he'll be able to pay half due rent." If your client does that call, you can make that call. But if the call is really going to be, this case is going to kind of, fizzle, and there's not going to be any money here, and he's not going to be able to rent. Well, make sure that you discuss that with your client before you make the call. Like that. Be careful. If you're going to be a third-party neutral, Nebraska Rule 2.3, every other state 2.4. So if you're an arbitrator or a mediator, there's kind of an affirmative obligation. If somebody there is confused and they think you are their lawyer, you have to clear up that confusion. And that gets us through Rule 2. That was much faster than Rule 1. Rule 3 goes fairly fast. Talks about meritorious claims and contention. You can't have frivolous claims. So if a claim or defense is unwarranted, you can't bring that to court. You can't bring up frivolization. But the exception to that is, of course, a criminal case. If your client is guilty and they did it, but they want to plead not guilty, well, even though that's totally frivolous, You're entitled to do that, and it's their right to put the state to its proof. And that applies any time that their liberty might be taken away. So even if it's not a criminal case, if it's some civil commitment or something, that would still apply. Expediting litigation, Rule 3.2, and our next code word is expediting. Expediting is our next code word for our webcast viewers out there. This is a pretty short rule. Lawyers shall make reasonable efforts to expedite litigation consistent with the interest of the client. So it doesn't say you always have to expedite litigation no matter what. It says you have to do it consistent with your client's interest. So if delay is in your client's best interest, well, you might delay it. But you have to expedite things consistent with your interest. So you don't just cave just because the other side says you have to expedite things. But in general, you want to expedite. You have to be candid toward the court under Rule 3.3. You can't do any of these things. You can't make false statements of fact to a court. Or if you discover that you made a false statement of fact, you have to correct it. If you know of adverse legal authority that's directly on point and it's adverse to you, and the other side didn't disclose it, you have an obligation to disclose that to the court. Even if the conditions don't apply, well, that case was 99% on point. Well, you probably, well, first of all, why are you in court if you're going to lose? But if you have some argument around it, you should probably bring it up to the court bench, because the others probably will find it. You have to use more common sense. But even if the other side didn't catch it, if it's directly a point, you have to disclose it. You can't offer evidence that you know is false. If you discover that it's false, you have to take corrective measures. If you think somebody's going to engage in crime or fraud, again, you might have to disclose that to the court. And these duties last until the conclusion proceeding. That's as well, in some cases, those extend to that. But in our case here, generally last till the case, of course. If you learn about some missed act that case 10 years ago, I guess you don't have to worry about that. I have never asked that. And once again, that's an exception to confidentiality, that crime and fraud exception. If it's an ex parte thing, if you're going in there for that temporary restraining order or whatever, well, then you have a little bit bigger issue. You have to disclose all of your acts, not just the good of your acts. We had a question about this earlier, fairness to opposing party and counsel. You have to be fair to the other side. You can't unlawfully obstruct another side's access to evidence, or you can't destroy documents. I think we probably do that. So that's kind of, you can't falsify evidence. I think you probably do that. You can't knowingly disobey the court rules, discovery requests, do a trial matters no, not going to be admissible. Number 6, it's not quite, it is obviously, because you have to be a little bit more careful about this one thing that you could inadvertently slip up just by being a zealous attorney. You're not allowed to request that somebody other than your client not voluntarily give information to the other party. So you're the plaintiff's attorney, and you're talking to some witness, and you tell that witness, and maybe you're being entirely truthful about it. The lawyer on the other side is a jerk. You would just this witness talk to him and say, when the defendant's attorney calls, you don't talk to him, okay? And maybe they're going to be perfectly good with that. Well, you probably violated this because that other attorney is a jerk. He has right to review that witness. So don't tell him not to give information to the other party. Exception if it's your client or an employee of your client, or if you think that person's interest will not be adversely affected. So maybe in that situation you might be able to squeeze it under that exception. But watch out for that. 3.5, impartial and decorum of the tribunal. Yes, in Minnesota we have to use decorum, but I put the states here differently. We have a little bit different. It's worded a little bit differently in Minnesota. both Nebraska use the same terminology. Can't seek to influence the judge or juror or other official by things that are prohibited by law. You can't make any ex parte contact with the judge or juror unless it's specifically or jurors authorized by law. Now, after the jury has been discharged, in general, yes, you're allowed to talk to them, talk to the jurors after the case is over, unless the judge orders you not to, or the juror said, I don't want to talk to you. So you have to respect that. And engage in representation, coercion, duress, or harassment. And you can't engage in conduct that is disruptive to tribunal. Those are also one day, I guess maybe I put the Minnesota rule here because I think this would probably be covered by rules here too, but it's one you might miss out on. In Minnesota, the way the rule is worded is that if you're involved in a case, obviously you can't talk to the jurors about that case. Minnesota has a separate one that says you as an attorney, even though you're not involved in any case, cannot talk to any juror about their case. Well, so in other words, if your juror is on a jury and you've never been in court because you do other things, you're do title track. Well, your neighbor is on a jury. He's going to talk to you about it. You're going to say, "Oh, I'm on a jury, and we're in the middle of the case, and here's what the evidence we heard today, and here's what I think of the evidence."